So what happens with your assets, your stuff, if you pass away without a will or a trust or any kind of estate plan at all? And in this video, we're going to talk about why it's crucial for any adult, and particularly people in California, because that's where I practice, to understand those risks and the complications of dying what we call intestate. So my name is Michael Pevney. I am an estate planning lawyer. I practice in California. Southern California, I do practice the entire state, and I create estate plans for families in California. Some of what I'm saying in this video may apply to you if you're outside the state of California, but some of it may not. And if you don't have an estate plan, are interested in estate planning, please subscribe or follow me. I've got a lot of content out there. Ask an estate planning question in the comments. I'm very oftentimes able to answer those questions, sometimes even with a video of its own. So what does it mean to die without any sort of estate plan at all? There's a legal word for it. It's called dying intestate. So what does that mean? What's intestacy? Is it an internal organ of some sort connected to the gallbladder? No, it means intestate, meaning you have not had a last will and testament, so you die without a will. And when that happens, you don't get to choose where your property, where your stuff goes after you pass away, and it goes through what are known as intestacy laws. Every state has their own laws. They kind of do the best job that they can to figure out where your property should go when you pass away, but they don't necessarily do the job that you want to do. And that's the whole point of estate planning. That's why I do what I do, to give people choice in order to decide where their stuff goes after they pass away. So one thing that happens when you die intestate, when you die without a plan, is it has to go through probate. So probate is the government-controlled, court-supervised, judge-approved asset distribution program. And in California, frankly, probate sucks, you guys, and it sucks for four big reasons. So first, it's expensive. It's based on the value of what you own at the time you pass away. In California, the average homeowner, if you do own real estate, it's going to cost somewhere in the $30, $40, $50, $60,000 range just to get it through probate. And where does that money go? It goes to lawyers, it goes to executors, it goes to court fees, there are appraisers involved, that sort of thing. And so that's reason number one why we don't want to die intestate. Reason number two, control. We kind of already went over that. You don't get to control where your stuff goes. You want to cut your kids out of the will, but the state doesn't say you get to do that, and you don't have a will at all. Guess what? It's going to your kids. There are very specific rules for spouses in community property states, whether or not you are in a community property state. Things might go to parents if you don't have kids. Things might go to siblings if you don't have kids. And then eventually they're going to go to very different, distant relatives, cousins that you've never heard of. In California, you can go out to third cousins twice removed, or third cousins thrice removed, or something like that. Number three reason why we don't want to go through probate is that it is a public process. So anything is open to the court, is open to the public. So if you don't want people butting into your business and your property after you're gone and know where it's going, or maybe there are kids there that are younger and maybe a little bit more vulnerable when it comes to fraudsters or tricksters and people that have buddies with great investment ideas, best that it not go through probate, so we know that that stuff isn't out in the open. And then the fourth reason why we want to avoid probate is time. It takes a really long time. The average probate in California that I'm seeing is oftentimes plus or minus about 2 years. And so we want to avoid this by not dying intestate. So then we've got to choose between a will or a trust. Those are typically the main estate planning documents that exist. Now, in California, I typically recommend that my clients, if they either own real estate or they have kids that are under the age of about, I'm going to say 25 or 30, depending on how responsible those kids are, your mileage may vary, that you have a trust. And the trust is a great estate planning document because it avoids probate and it gives you a lot of control over where things go. So, all four of those reasons to avoid probate, a trust satisfies all of them. Things happen faster, you get even more control over how things are distributed. Let's say there's little kids, say you got a 10-year-old and you don't necessarily want them inheriting things as soon as they turn 18 without any strings attached. Well, guess what we can do with a trust? We can attach those strings. You can control their inheritance from beyond the grave. And some people want to do that well, some people just want to be controlling, but some people actually want to look out for what might be in the kid's best interest because you know the kids better than the government does, right? And you know their level of responsibility. Are they going to be able to handle inheriting hundreds of thousands of dollars, $1 million, maybe even more in order to do that? So a trust allows us to do that, and it happens quick. Typically involves death certificates. We basically take a death certificate to the financial institution where the account is now titled in the name of the trust, or we basically got to show a death certificate to the county records office, the land office, or as we call it in California, the clerk recorder's office. And that's generally how things get transferred to the person that it's going to be transferred to. And a will can be more appropriate in some other states where things don't take as long. But a will, importantly, especially if you're passing along real estate that has some value to it, still has to go through that probate process, which in California, again, we really, really want to avoid. And so if something does have to go through intestate laws, meaning no estate plan at all, you follow the state's estate plan. By the way, there is an estate plan if you don't have one. It is the state's, and you might not like what it says, and you might not like where things are going. So this is what it can sometimes lead to. Financial strain, because somebody needs to get into that property or start paying those bills or keep up the home, pay the mortgage on the home. And when there's no clear idea of who that's going to be, sometimes that can involve a legal battle. Maybe there's a second spouse and a child from a previous relationship that are going to go into court with their own lawyers and say, I need to be the executor. I need to be the personal representative. And this belongs to me and that belongs to me. And they said they were going to give this to me. And they said I was going to get this. And maybe they even scribbled something down on some sort of document that doesn't make out, legally have the requirements of a will. By the way, many states do have provisions for a handwritten will, what's known as a holographic will. Please don't do that. It's a mess. Technically, they're legal and they do exist, but even if you do one on your own, many states have their own sort of will format that they can do, and we want to have those things either witnessed or notarized or whatever formality needs to go by your state. And so we talked a little bit about wills there, and we talked a little bit about trusts there. So how do we set up a will or a trust? The best way to do things is to talk to a qualified estate planning lawyer in the state that you live in. Now, I only practice in California. I do not intend to ever take another bar exam. It's not a lot of fun. In California, it's 3 days long, kind of sucks. And there's 40 million people in California, so that's enough of a client base for me. And so if you do not have that estate plan set up and you're outside of California, find a qualified estate planning lawyer in your area. If you have a financial professional that you trust and they recommend people, or you have a friend or a neighbor that's a professional or that has something set up, you can always talk to them. I have recommendations for people in a couple of different states, but definitely not all of them. So in this video, we talked about what happens when you pass away without having any sort of will or trust set up. It has to go through this program, this court system using the intestate laws. And the intestate laws, remember, are the state's estate plan for you if you don't have anything set up, and you very well may not like what it is. So once again, my name is Michael Pevney. I'm an estate planning lawyer in California. Please follow me for more estate planning information. And if you live in California and you don't have that estate plan set up and it's time to set one up, you can follow the link in my profile or in the description to set up a time to meet with me for free. Thank you for Thank you for your time and thank you for your attention. Have a good one.